Mahatanda Mahaka Surya Koti Samayamas Nirvana Kuri Kanvagani Shivasaya Asataman Sagadamaya Kamso Jyoti Kamani Surya Amrita Shanti 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 बच्चों को कुछ ऐसे ना soulful and melodious start to our event. On this auspicious note, let us proceed forth with our program. On this wonderful morning, we are privileged to have amongst us our distinguished dignitary, Ms. Simrat Kaur, Director of IPR at the Department for Promotion of Industry and Internal Trade, Ministry of Commerce and Industry, Government of India. A very good morning to our eminent guest, Ms. Simrat Kaur, Principal Dr. Ram Singh in absentia, Vice Principal Ms. Indrajit Kaur, Headmistress Ms. Manisha Verma, school leaders, teachers, and dear students present here, and those joining us live through the online stream. Delhi Public School Mathura Road is extremely privileged and proud to be hosting this awareness program on intellectual property rights. And we extend our heartfelt gratitude to the Ministry of Commerce and Industry, Government of India, and the Department for Promotion of Industry and Internal Trade for this remarkable opportunity. As students of the 21st century, learning about intellectual property rights is not optional, it is essential. And who better to guide and enlighten us on this vital subject than Ms. Simrat Kaur herself, a distinguished expert in the field of intellectual property rights. Ms. Simrat Kaur serves as the Director of Intellectual Property Rights at the Department for Promotion of Industry and Internal Trade, Ministry of Commerce and Industry, Government of India. Ma'am oversees key facets of India's intellectual property ecosystem, including copyright designs and the initiatives of the Cell for Intellectual Property Rights Promotion and Management. Her expertise in IP law, regulatory frameworks, and legal policy development reflects a deep commitment to strengthening India's IPR architecture and aligning it with the best global practices. Through her dynamic engagement with government bodies, industry leaders, and international organizations, Ms. Simrit Kaur continues to champion innovation, creativity, and a robust rights driven approach to intellectual property governance. Ma'am, it is indeed a moment of tremendous delight and pride for our school to have you with us today. We are truly honored. I now request our student representatives to kindly felicitate Ms. Simrit Kaur by presenting a token of our gratitude and warmest welcome to ma'am. We at Delhi Public School, Mathura Road, once again extend a heartfelt welcome to Ms. Simrit Kaur, all our esteemed guests and school leaders joining us today. And we thank you, ma'am, for taking our time to enlighten us all today. Now, I would like to invite Ms. Simrit Kaur to address the gathering with her empowering words and invigorating insights. Ma'am, the stage is yours.
Good morning, everyone. Thank you. Thanks, everyone, for this warm welcome. So I am Simrat Kaur. I am director at DPIIT. We oversee intellectual property related work. We have a subordinate office, which is IP Office of India under DPIIT, which registers all forms of IP, be it copyrights and designs and GIs and trademarks. So I'm here today to give you a little bit of insight into what are the different forms of IP protection and how can you benefit from that and what you need to do to seek that protection and to enforce those IP rights. Can we have the print? So how many of you have heard about IPR? Can you please raise your hands? Students who have heard about intellectual property rights. Yes, please. Yes. So, have you heard about white book? It's why a World Intellectual Property Organization. That's a United Nations agency which works on spreading awareness about IPR and also harmonizing the laws of various jurisdictions on IPR because it's a territorial right. Various nationalities, various countries, they have their own domestic laws on copyright, trademark, and WIPO works on harmonization of these laws. So this is how they define IP. They say it refers to creations of the mind, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. So something which is created by human mind, something which can't be touched, which can't be seen, but still it holds immense value, that is called intellectual property. It's just like invisible currency of the modern world. You must have heard about knowledge economy. What is knowledge economy? It is powered by intellectual growth, intellectual capital, and innovation. So any economy which heavily invests in education, software development, technology development, and R&D, that is called the knowledge economy. India has the potential to become a very strong knowledge economy, but what do we need to do that? What do we need to achieve that? We need to create more and more intangible assets and create more and more value in those intellectual assets, commercialize them well, and also protect them against any sort of misappropriation, misappropriation by third parties. So you need to first create IP, protect it, and also create value in it, monetize it, and commercialize it. That will help India become a very strong knowledge economy. There are different forms of intellectual property, copyrights, designs, trademarks, patents. Copyright protects original literary works, artistic works, uh, photographs, dramatic expressions. So anything which is your original expression, something that you created yourself, something that you didn't copy from somewhere else, that is copyrightable. It could be a poem, it could be a story, could be any script, any painting, any sculpture, any photograph that you click. So all those are your original expressions, and you get a copyright over those expressions the moment you create that. So this is one such IP where you don't need any registration. You don't need to go and apply for seeking statutory protection, for seeking monopoly over the work that you created. You don't need to go and file the application for that before IP office. The moment you create it, it's yours. But this is not the case with other forms of IP. Design. This is one such limb of intellectual property which protects outer appearance of products, the aesthetic appearance of a product. So there could be some chair here, some table which has some unique shape. So somebody who created that unique shape, which gives a like very different aesthetic appearance to that chair or table, he is the creator of that design, and because he created something novel, something that didn't exist earlier, so he gets a design right over that. So for designs, to go and file the application. And one thing that you must keep in mind about designs is once the design is published, you can't go and seek protection. Before filing the application, it shouldn't be published. It should be an unpublished and novel design. So once you create any design, once you have the blueprint, you have to go and file the application. Otherwise, once you publish it, market the products, then you lose the protection. There are some rights which are available to the owners of unregistered designs under common law, but then the threshold to enforce those rights is like it's very high. The proof the kind of proof that you have to, the kind of evidence that you have to submit and adduce is very heavy. So it's very difficult to enforce a design right without having a registration for that design. And then you have trademarks. Trademarks are the symbols, the names, it could be taglines as well, which perform the source identification function. They distinguish the goods and services, your product, your service from the services from the products of others. So if you look at Nike shoes, right? So if you look at that symbol, you associate those shoes with a particular company, right? And you expect some level of quality. If you are ordering for a McDonald's burger, you expect certain level of quality. So you associate McDonald's with, a particular organization. So that's the power of a trademark. It identifies the products and services of any one organization or one business. And then we have patents. Patents protect inventions, something which is novel, which is not state of art, which you created, and it has industrial application. It solves some problem. It's not, like a state of art. It's not. It was not there earlier. You invented it and you solved some problem, and that has industrial application. That is patentable. It could be a process. It could be a product. So it could be like this is a phone, so it could be some processor, some camera system there which is used in the phone, having some new features. And it could be a process with which you come up with a new medicine which cures some ailment or disease, something which was not curable earlier. So you came up with a new medicine. So the process with which you prepare that medicine, that can be patented. So once you patent it, nobody else can use that process and make the same medicine. Nobody else can actually, market that product without your authorization and consent. So intellectual property is always considered as the weakest link because uh, we focus a lot more on tangible assets. When we create a business, we focus a lot on buildings, infrastructure, real assets, assets that you can see and touch. We always end up ignoring intellectual property assets, and which hold the real value of our business. Nowadays, even small enterprises, MSMEs, and startups are recognizing the importance of intellectual property, creating new IP and protecting that. And that's something which is actually, it's quite, I mean, it's good that people are recognizing the value of IP. So there are different forms of trademarks. It could be a word mark, it could be a figurative mark. Figurative marks are logos, which have some sort of artistic element. And then we have stylized marks. Coca-Cola is always written in a certain stylization, certain specific font. So that font is protected. That's a part of their trademark. And then we have sound marks. These are unconventional trademarks. So earlier, only word marks and taglines and logos were recognized as trademarks. It was believed that only these can perform the source identification function. But nowadays, many jurisdictions are recognizing non-conventional marks in the form of sound marks, smell marks. Very recently, Indian IP Office granted protection to a smell mark as well. Have you ever heard? I mean, you must have heard Airtel ringtone, right? So, the moment you hear that ringtone, you associate that with Airtel. Because you associate that music with Airtel, that itself proves that that music performs the source identification function, and hence it can be a trademark, and it's a protectable trademark. And then you have 3D marks, shape of Coca-Cola bottle. That's a very unique shape. So nobody else can, use that shape and market a product. Same category of product. Nobody else can use the same shape of the bottle for soft drinks. So because they have a protected trademark. Uh, Any questions on kinds of trademark and what is the purpose of trademark protection? Why should you seek trademark protection? Anyone? It's not. I need to go back to the previous slides. Bottom one, अब previous one, अगर उसको slides पे करना है आप wait, show करना देखना हाँ जी which one so these are different examples of trademarks. Apple का लोगो है इसमें, Microsoft का लोगो है, Nike का लोगो है. So all these trademarks are duly registered trademarks. These companies have sought protection in these logos. They have registered it in different jurisdictions and they monopolize them. They have exclusivity over these stylizations, over these logos. Nobody else can use these logos for similar categories of goods and services without their permission. So, next is design protection. As I mentioned, design refers to the aesthetic aspect or outward appearance of a product. Um and it has to be novel, it has to be unique and unpublished. Um Designs which are contrary to public morality, public order, they are not registrable, and functionality is not protected. So something which is a functional feature, it cannot be protected under design. सो एक चेयर है जैसे उसमें एक चेयर की शेप है वो जरूरी है उसको चेयर कहलाने के लिए राइट सो दैट्स समथिंग दैट is required for performing a certain function. So that's a subject matter of patents. You can't register it under designs. Design just protects the outer appearance. उसकी जो बाहरी सुंदरता है जो उसकी outer appearance है उसको design protect करता है, not the functional features. If there is any functional element that cannot be protected under designs, but if it's a new function that it performs, it is novel, it's inventive, it has got some inventive step, then you can go and seek protection for that under patents. What is the term of protection? So design is granted for a very short term, only for 10 years, and then it's extendable for 5 more years. It's 10 plus 5. Copyright, on the other hand, is longer. So there, the term of protection is lifetime of the author. plus 70 plus 60 years. So even after you die, if you created something which is copyrightable subject matter, you will continue to retain monopoly over that. Your legal heirs can earn the royalties because of that copyright. It will continue to vest for 60 more years after you die. So that's the longest term of protection. Design on the other hand is like that protection is shorter. It's just 10 years plus 5 years. First initial term you get it for 10 years, and then you can file the application for renewing it for 5 more years. These are different kinds of designs. These are three-dimensional designs. If you see, all of these have some, unique features, something new, which makes them special, which makes them novel, जो पहले कभी नहीं था, कुछ नया. So that's why they get protection. And then we come to copyright. These are different kinds of copyrightable subject matter: music, films, paintings, architectural drawings, sculptures, photographs, software. Source code is also a copyrightable subject matter. It's a literary work. So if you create some new software, if you develop some new software, you have write the source code for that. You can go and seek protection for that source code under copyright, and you don't even need to go and file the application. The moment you create that, develop that source code, it's yours. And if you preserve the evidence of originality, you can claim copyright on that anytime. And if somebody copies that without your license, without getting prior authorization from you, you can always go and file a suit against that person. You can sue that person in the court. So that's the power of copyright. Now, copyright protects original expressions, not the ideas. So if you have some idea and you have not developed a concept, it's not a full-fledged concept, then you can't copyright it, because ideas are not protectable under copyright. Expressions are, original expressions are. So if you put something on paper, if you put that idea on paper, you developed a full-fledged concept, then yes, you can claim the copyright. Otherwise, not. Facts are not copyrightable. So if there's like something is going on in your country, and you write something about it, some political affair, and that's a fact, so anybody can write about that. You can't say I wrote about it, nobody else can write about it, I hold the copyright. No. But yes, the way you write it, in the manner you write it, then you can protect that particular expression, because that's your original expression. So, we have assembled here today, we are talking about intellectual property. If any one of you narrates, writes about this event on the paper, and you write it in a unique expression. This is how we discussed about intellectual property. This is what we gained from this discussion. So if it's your expression, nobody can copy those words, because that's your copyright. But that doesn't mean nobody else can write about this event. Anybody can. So that's how ideas and facts are not protected under copyright, but original expressions can be. Term of protection, as I mentioned, is lifetime of author plus 60 years, and registration, as I mentioned, is not mandatory. The moment you protect it, it's yours. You just need to preserve the evidence of originality, so that you can prove that this is something that you created. You didn't lift it from anywhere else. It's not the plagiarized version. You didn't copy it from somewhere else. It's your original creation. So for that, you will need to prove that, for which you will need to preserve the evidence. It can be in the form of the blueprints. It can be in the form of emails that you sent to your friend, or maybe that sent to yourself, or the copies that you saved in your system. the date of those copies, the date on which you saved those versions. So all those evidences can help you in establishing your copyright if somebody contests it tomorrow. Patent, as I said, it protects inventions, something which solves a problem and which has an industrial application. Patent is granted for a limited term. It is granted only for 20 years, and it can't be renewed thereafter. You get the protection for 20 years, you can monopolize it, nobody can use that product and process for those 20 years without your license. But once 20 years are over, then that invention falls into public domain. Anybody can use that, and that is how generic medicines, for example, are made. So, if a pharma company holds a patent on certain medicine, then they have that monopoly for a duration of 20 years. After that, it falls into public domain, and any other pharma company can come up with that medicine because it's in public domain. It's no more patented. These are different kinds of inventions. There could be new chemical formulas, um, uh, new electronic processes. It could be any kind of invention. And then we come to geographical indications, uh, which are called GIs. Anyone heard about a GI? Is anyone aware of geographical indications? Yes, please. Yeah.
Great example of this is the polar free temple. If you copy the Prada, so it gives them a legal ownership that place a legal ownership over that creation because it's from there.
Something which originates from a particular territory, right? And the quality of that product is attributed to that territory because the people of that territory have certain skill, certain raw material is available there only, right? Which contributes to the quality of that product. So that is why GIs are granted. We have different GIs from different states. For example, Bengali Rasgulla. So it has got a unique taste. That's spongy Rasgulla. And then we have Fulkari from Punjab, a very unique kind of embroidery. People in that area had skill to, to develop that. So GIs protect products which come from a particular territory, and the quality of that product is attributed to that territory only. It's because they have some raw material, some product which is used in preparing that is comes from that particular territory, or the people who reside there, certain community, they have got some unique skill to prepare that. As I just mentioned, Fulkari. So the moment you see this fabric, you see this embroidery, you get to know that this is Fulkari and this comes from Punjab. Now, if I ask you what kind of IP is this? Yeah.
Design
Yes. Why?
it has a different design than normal brushes.
Yeah. Because it is of different shape, right? The outer appearance is different. Why is it not a copyright?
Because it is not it is a normal brush and there are many brushes so it's not a copyright.
Why is it not patented? I mean, why can't it be patented?
because anyone can make it is not a patent because
So it's design, right? Because it's an outer appearance. जो बाहर का उसका shape है, सारे brushes का वो अलग अलग है, वो design अलग अलग है. So anybody who actually created that unique design has a design right. So it's not an invention. It's not solving any problem, right? So it's a design right. What kind of IP is this? Yeah. No one? Okay. This is a phone. Phone will also carry the trademark, the Apple symbol. So it has the trademark as well. And there could be, some inventions. There could be a unique processor inside it and unique camera system, which are all patented. So the technology inside that phone is patented technology. And then the shape of the phone, that is a design feature. So it has trademarks as well, it has design, and it has patents as well. Anyone wants to say something? Any questions? This is what kind of IP is this? Ma'am, my question is that why patent is for only 20 years and why can't it be renewed? See, that's a good question because we don't want inventions to be monopolized by a particular organization for perpetuity, right? So we want those inventions to fall in public domain, like for example, some medicine. So if we give patent to a pharma company for perpetuity for unlimited term, then they'll monopolize it, and they will be able to make that medicine for years and years, right? Nobody else would be able to do that, and then they will have very high prices for that. They'll set high prices. So many people would not be able to afford that medicine. Right. So after a point of time, we also want to encourage innovation. We want those organizations to invest in research and development and come up with new medicines, to come up with new inventions. So for that, we need to reward them. We need to give them certain level of monopoly for certain period of time. Otherwise, why would somebody invest in R&D and create something new? If you invent something and anybody can use that, and you can't even monopolize it for 5 years, then what will motivate you to come up with something new? Right. So you have to be rewarded for your invention. And 20 years of monopoly, 20 years of exclusivity is essentially that reward. Right. So that will motivate you to come up with new and new inventions. But then it can't be unlimited protection because we would want that, the same process, same product can be used by somebody else after a certain period of time so that prices can reduce and more people can afford that medicine, and there's more competition in the market. So that's the reason why patents are granted for limited term. Understood? Thank you, ma'am. Any other question? Yes, please. Sanju. Like medicines patented. Then generic medicines we made or not at that time or the period of 20 years? So for a period of 20 years, the company who has the patent, that company holds a monopoly. But if you get the license from that company who holds the patent, if you are a licensee, a duly authorized agent, then yes, you can. But otherwise, I mean, without a license, without authorization, you can't because that's a patented product and they hold monopoly over that. But after 20 years, once patent expires, yes, you can. But if government wants to subsidize the rates, then can generic medicines be made by government or not? So that's That's the entire reason for which I just explained that patent is granted for a limited term, and India has always played a very active role in discouraging evergreening of patents. So, in some jurisdictions, these pharma companies come up with a new medicine and they patent it, and then they change the chemical formula a little bit. They make some very immaterial changes and then they apply for the fresh patent. That is something that India discourages. So our law doesn't allow it, and our law was interpreted by the Supreme Court of India in such a manner in one of the landmark cases a few years back that which like enables India to discourage this kind of evergreening of patents. So we emphasize that it has to be a completely new formula. You cannot, just make immaterial changes to those formulas, those medicines that you patented earlier, and you know, get the protection extended. Because then, this is how we, discourage evergreening, discourage, monopoly for perpetuity, so that our public can have, those afford those medicines on subsidized rates and low rates, and uh, more and more people can actually benefit from that, and it I mean strengthens our you can say boosts our generic industry as well. Yeah. Yes. Sorry, I can't hear you. Can you
Like Apple, my camera design is a trademark of Apple. And other mobile phone companies also use the same design of the camera. So Apple can sue them.
so Apple phone has got the
Camera
logo,
design.
right, and also the design. So design is the shape of the phone. So you're saying if somebody else uses the same shape, then can Apple sue them? Yes.
Like other phone companies use the same design of the camera. So Apple, why doesn't Apple sue them?
Is the shape of the camera visible? No. It's not the outer appearance. It's not the shape which is visible to the eye. So if it's visible to the eye and it has got a unique shape, then obviously you can. But if it is not, then it's not a design feature and it is not protectable. If that camera system has got some unique features, that's a domain of patent. Design protects the outer appearance, the shape. Anyone else? Yes.
Apart from outer countries like China, they have launched foldable phones. How can Indian brands copy the foldable phones idea? They are copying the design, the outer appearance.
So, see, you cannot copy the design if that Chinese entity has protected its design in India, filed the application, and it's a registered design. So you cannot copy that. You will have to go and seek license from them if you want to use that design and market the product. You have to be their like authorized licensee. If you are not, you can't. Provided it's a protected design.
Oh, okay. Thank you.
Yes.
Many countries and marketplaces, they make fake versions of those bags and all. And in many places, this is a profession of like master copy, making a master copy. And in so can't don't sue them. Why don't they sue those master copy makers and
they sue them better. So that's called counterfeiting. That's trademark infringement. It could be design infringement also if you have shape of a bag which is protected as a design, and somebody else is actually marketing the bags with same shape without the authorization of the design registrant, or Chanel's bags, or maybe Louis Vuitton's bags. Somebody else is using the trademark, the logo, without the authorization of the trademark owner. So then that's counterfeiting. That's illegal. And if you're marketing such illegal products, if you're displaying those illegal products anywhere, then that's illegal. You are doing an illegal activity and you can be sued. And it's not the case that these companies don't sue these infringers. They do. But yes, it's the policy of the company. They decide how aggressive they want to go. Should their, like IP enforcement policies be too aggressive and they should be filing suits everywhere, multiple litigation actions, or they just choose to, go and file a suit against handful of infringers, and that actually helps them, discourage others, and that has a deterrent effect. So if it doesn't have a deterrent effect, couple of actions, then they file more litigations. So it depends on their IP enforcement policy. If they choose to go very aggressive, they file multiple suits. If they don't, they file handful of suits. But that does not mean they can't. It's their choice. So if some illegal activity is happening somewhere, counterfeits are displayed, counterfeits are sold in some markets, then they can always invoke the civil as well as criminal remedies under our IP Act.
Thank you, ma'am.
Anyone else? What is this sign? What is this? What form of IP is this? What kind of IP is this? Yes.
And then it's design.
Is this design?
Shape.
Shape looks like. Yes. So these are musical notations, right? So music, yeah, sound. It can be a trademark, but otherwise, music is copyrightable subject matter. So it can be copyrighted. अगर आप कोई नई धुन बनाते हैं जो पहले नहीं है, तो वो आप कॉपीराइट कर सकते हैं. Yes, it could be a sound mark. अगर आप ये प्रूव करते हैं कि वो साउंड जो है that is performing some source identification function. You are a businessman and you are an entrepreneur. You are, marketing certain products, and those products are, identified with you because of some sound mark. Then yes, it could be a subject matter of trademark, but otherwise, it's copyrightable subject matter. What are the benefits of IP protection? First of all, it gives you positive market image. So if there is a product, it has got that symbol of R. अगर उस पे ट्रेडमार्क लोगो लगा हुआ है और लोगो के ऊपर R symbol है, it creates an impression in the mind of the consumer that it's a registered, it's a well protected, legally protected trademark. और legally protected trademark के नीचे कोई product बिक रहा है, it must be of certain, good quality. So it creates positive image in the market if you protect your intellectual property. So अगर आप उसके ऊपर R नहीं symbol होगा, that means your trademark is not a registered trademark. So it's always better to go and seek protection for your brand if you are floating some products carrying that brand in the market, because then your product will have more value. And then second benefit is exclusivity, monopoly. Once you obtain IP protection, then, as I mentioned earlier, you gain exclusivity for certain time period. If you have the copyright, it is for lifetime plus 60 years. If it's a trademark, it's for 10 years plus. you can renew it every 10 years for perpetuity. And if it's design, it's 10 plus 5 years. And if it's patent, then it's 20 years. Different time frames for different forms of intellectual property. But for that time period, you get the exclusivity. Nobody else can utilize your work, your invention for that time period without your prior authorization. If somebody does that, that is infringement, and you can invoke criminal remedies against that person or go for a civil suit and seek damages, seek compensation, right? So it gives you exclusivity, monopoly over that invention, over that design, over that, copyrightable subject matter for a certain time period. And then enhanced bargaining power in transactions. So if you today you build a business and 10 years down the line, the brand that you adopted for that business, that holds a lot of value, right? And you tomorrow want to sell out that business, all the real as well as intangible assets associated with that. So if you protect your brand, if you protect all your designs, if you protect your IP, then tomorrow when you negotiate the price in that deal, you will have much more bargaining power. So if your IP is not protected, then the acquiring company, the organization which will be acquiring your business will not give you enough value because they'll say you don't have your IP protected, right? तो आपका IP created तो है, लेकिन आपने उसको protect ही नहीं किया है, तो उसकी value कम हो जाती है. तो जब भी कोई acquisition होती है, whenever there is some merger, some acquisition, so then they do a DD, due diligence of your assets, both your real assets as well as your intangible assets. And when they see that you have not got enough protection over your IP, you have not registered your intellectual property, then they give less marks, you can say. अगर 5 marks है तो उसमें से उसको 2 देते हैं. आपका ब्रांड है, उसकी ब्रांड वैल्यू अच्छी है, लेकिन उसके प्रोडक्ट्स मार्केट में बहुत अच्छे बिक रहे हैं, उनकी अच्छी क्वालिटी के प्रोडक्ट हैं, आप लोग उसको पसंद भी करते हैं, बट आपने वो ब्रांड रजिस्टर ही नहीं कराया. सो उसमें आपका 1 मार्क जो है, 1 मार्क 2 मार्क कम हो जाता है उसमें. सो उसमें आपकी बार्गेनिंग पावर भी उस ट्रांजैक्शन में कम हो जाती है. सो यू मस्ट प्रोटेक्ट योर इंटेलेक्चुअल प्रॉपर्टी. हायर मॉनेटरी रिटर्न्स. आपको कहीं पे भी अगर आपका आईपी प्रोटेक्टेड है तो हमेशा आपको उसकी ज्यादा वैल्यू मिलती है. सो दिस इज व्हाट दिस इज स्टारबक्स ट्रेडमार्क. You must have heard about this case, right? Yeah. So it's visibly very similar. If you look at both the logos, these are very similar. What did they try to do? They tried to use the same color combination, same stylization, other visual features of the trademark, and ride upon the goodwill of Starbucks, so that somebody gets a mistaken impression that okay, this is Starbucks cafe, and enters that cafe, orders for the coffee, and they can easily pass off their coffee as Starbucks coffee. So in order to pass off your products as somebody else's product, you will need to first use their trademark. So sometimes people use the same brand as is without any alterations, and sometimes people come up with slightly altered brand. थोड़ा सा उसको बदल देंगे, थोड़े से उसके फीचर्स को चेंज कर देंगे, ताकि वो ये डिफेंस ले सके कि उन्होंने एज इज कॉपी नहीं किया है. दिस इज नॉट काउंटरफीटिंग, दिस इज नॉट इन्फ्रिंजमेंट. तो उनको लगता है कि उसको थोड़ा सा चेंज कर देंगे तो कंज्यूमर कंफ्यूजन भी हो जाएगी और उससे उनको बेनिफिट भी मिलेगा. पीपल विल गेट कंफ्यूज एंड दे विल बाय देयर प्रोडक्ट्स एंड देन मिस्टेकन इंप्रेशन दैट दिस बिलोंग्स टू Starbucks or some other reputed company. So they'll be able to ride upon the goodwill of the other company, and plus they will not be held for infringement. But that's not the case. Even if two brands are similar, if they're not identical, even then that is trademark infringement. So the test is consumer confusion. अगर consumers को confusion हो रही है उसमें there are like there's sufficient similarity between the two logos, between the two trademarks, then it's very much infringement. Similarly, so the defendant can say the person who actually adopted the trademark Qma, they can say it's completely different. P and K, they are different, but still you can say they are phonetically similar because last three alphabets are same, and if you look at stylization, visual features, that is quite similar. और ऊपर से जब हम वो बोलते हैं तो phonetic similarity है. So anybody can get confused. That is why these are similar trademarks, and this is a case of trademark infringement. Why should you respect others' IP? तो अभी तक हम बात कर रहे थे अपना IP प्रोटेक्ट करना चाहिए, उसको किसी को यूज नहीं करने देना चाहिए. बट अगर हम दूसरी तरफ से पूछें कि why should you respect somebody else's IP? Because it's someone else's hard work. Right. If somebody else created something, उसका उसमें hard work गया, उसकी innovation थी, उसकी creativity थी, तो अगर आप उसको ऐसे ही lift कर लेंगे, तो और उसको कुछ there's no means to protect that. उसके पास कोई mechanism ही नहीं हो उसको protect करने का, law उसको mechanism ना दे, तो then will that person be ever motivated to create something new, to put that much of effort? No, right? So to build a culture of honesty and to respect someone else's hard work, to encourage creativity for everyone, to create an ecosystem of creativity, you need to respect others' IP. Plus, with the very simple reason it's a law. If you don't respect others' IP, if you copy it, अगर आप बिना उनसे पूछे, बिना उनका लाइसेंस लिए किसी की इन्वेंशन को यूज करते हैं, किसी के डिजाइन का वो आप कॉपी कर लेते हैं और वही मार्केट में आप उस तरह के डिजाइन वाला प्रोडक्ट उतार देते हैं उनसे पूछे बिना, या आप किसी का एक्सप्रेशन चोरी करते हैं, राइट? यू समबडी एल्स, यू आई मीन यू राइट अ स्टोरी जैसे किसी और ने लिखी है, आपने उसी वर्ड्स में वो स्टोरी लिख दी है. So all these acts are acts of infringement, and you should avoid these because there are criminal remedies. Remember, if the creator, the IP owner, chooses to go after you, if he chooses to file a suit against you, he can extract compensation, he can extract damages. अगर वो प्रूव कर देता है कि ये infringement है, and moreover he can go and file a police complaint against you, and you can be put behind the bars for up to 3 years. As per our law, it's infringement. If it is established, then the criminal remedy is there, and you can be jailed for up to 3 years. तो imprisonment term जो है वो 3 साल तक जाती है, plus 50,000 से लेके 2 लाख तक फाइन भी है. So this is there under Copyright Act as well. Trademark में भी है. So all these IP statutes have criminal remedies. Where do you register IP? So we spoke about the importance of seeking statutory protection, filing applications for registration. So अगला question होता है कि कैसे register कैसे कराना? रजिस्टर कराया जाता है आईपी ऑफिस में, एंड टेरिटोरियल प्रोटेक्शन होती है हर कंट्री में. इफ यू seek protection in India, that does not mean that you also monopolize the brand in US. For that, you will need to go and file the application in US. यूके में करना है तो हाँ यूके में जाके आपको अलग से ट्रेडमार्क एप्लीकेशन डालनी पड़ती है, तो इट्स टेरिटोरियल प्रोटेक्शन। एंड इंडिया में आपको आईपी ऑफिस, आईपी इंडिया, अगर आप आईपी इंडिया गूगल करेंगे सो उसमें आपको CGPDTN विच इज सबऑर्डिनेट ऑफिस ऑफ DPIIT, उसकी वेबसाइट पे आप जा सकते हैं। देयर यू कैन रीड अबाउट ऑल फॉर्म्स ऑफ इंटेलेक्चुअल प्रॉपर्टी, हाउ यू कैन फाइल फॉर प्रोटेक्शन। FAQs भी है उसमें, चैटबॉट भी है विच कैन आंसर योर क्वेश्चंस। So we are trying to simplify the processes so that it is not too complex for people to, it's not so difficult for people to file for IP protection. We are trying to minimize the compliance burden, simplify all the formalities, the forms requirements and the evidence requirements. तो जैसे जैसे साल दर साल हम उसको कम करते जा रहे हैं ताकि नॉर्मल सिटीजन्स के लिए वो बहुत ज्यादा कॉम्प्लिकेटेड प्रोसेस ना हो। ज्यादातर केसेस में दे डोंट हैव टू गो एंड अप्रोच अटर्नी और उनको प्रोफेशनल फी नहीं पे करनी पड़े, वो खुद ही करें, खुद ही कर पाए, वो एप्लीकेशन फाइल कर पाए। बट स्टिल whenever those applications are hit by certain objections, IP office examines them and then they feel that okay, this is not fit for protection, or they have some queries and they send a scrutiny letter or examination report to you, then you can, I mean, you may need to hire an attorney services, but otherwise, जो फाइलिंग है उसके लिए जैसे ट्रेडमार्क फाइलिंग में आपको जरूरत नहीं है, इट्स वेरी सिंपल फॉर्म। आप कुछ कुछ उसके साथ एविडेंसेस साथ में देने पड़ते हैं। अगर आप यूज कर रहे हो ट्रेडमार्क ऑलरेडी, so you will need to state the first date of use and you will need to annex an affidavit of use along with the application. So there are some documentation requirements, but those are very simple. वो आप खुद भी कर सकते हैं. You don't need to hire an attorney. And similarly for copyright protection, it's a very simple form. उसमें publication details आपको देनी होती हैं, creator details हैं, तो आप details खुद ही भर के खुद भी आप अप्लाई कर सकते हैं। उसमें इतना कुछ complicated process नहीं होता है। Moral rights of artists. So yeah.
And there are some websites where you can buy some domain or like, for example, if I have a product and I want a name for it, so I know there's a website where I can search any and buy it. Some are very and
Yes. डोमेन आपको अलग राइट देता है, ब्रांड आपको जो है वो अलग राइट देता है। पहली बात तो दो चीजें, दो अलग अलग चीजें हैं। To conduct a search for the availability of a brand, you will need to look at the database of Indian IP Office. So there are certain classes, 45 classes हैं, categories हैं for different products. For example, for clothing you have class 25, right? For chemicals you have class 1. So if you want to adopt a brand for clothing business, so then you will check in the public database of IP office whether a similar mark or a same mark is already obtained, already monopolized by a third party in class 25. तो आप क्लास 25 में चेक करोगे और आप उसको अगर देखते हो और उसके बाद आप पाते हो कि वो किसी ने भी अडॉप्ट नहीं किया है, nobody else has filed for the protection or registered it, then you can assume that the mark is available for registration. It's available for adoption. You can use that. But for domain में आपको डोमेन रजिस्ट्रांट्स होते हैं जैसे कि GoDaddy है, तो आप वहां से अवेलेबल डोमेन्स जो है उसको बाय करते हो। बट अगर उस डोमेन के अंदर कोई रजिस्टर्ड ब्रांड आता है, फॉर एग्जाम्पल माई नेम इज सिमरत कौर एंड आई हैव गॉट माई ब्रांड रजिस्टर्ड, and tomorrow if there is a domain simratkaur.in, right, and I registered Simrat Kaur for clothing, और आपने एक डोमेन ले लिया simratkaur.in और आप भी क्लोथिंग बिजनेस उसमें चला रहे हैं, so then I can sue you. So वो प्रोटेक्शन वहां तक जाती है, बट देन आपको डोमेन रजिस्ट्री अलग होती है, डोमेन रजिस्ट्रांट्स अलग होते हैं, वो .in के रजिस्ट्री के अंडर आता है, निक्सी के अंडर आता है। उसमें अगर कुछ डिस्प्यूट्स होते हैं वो आपको उसके लिए अलग डिस्प्यूट रेजोल्यूशन सिस्टम है, डोमेन्स के लिए, ब्रांड्स के लिए अलग है। Those are different categories, but still there is overlap.
Oh, okay.
Yeah.
Thank you.
Yes, please.
Ma'am, I want to ask, why do we have timelines? Like, for example, we got patterns which are 20, which have 20 years, and designs of 10 plus 5 years. So why do we have timelines?
See, I explained the reasoning about patent protection. उसका जो term 20 साल क्यों माना जाता है, क्यों रखा गया है. इसी तरह से डिजाइन जो है उसमें 10+5 इसलिए होता है because designs are generally short lived, right? In many product categories जो designs नए बनाए जाते हैं so they have a very small shelf life. If you look at fashion accessories, if you know like talk about clothing, अगर apparel designs को अगर आप देखें तो आज आप कोई नया डिजाइन लेके आए, नई कलेक्शन लाइन आपने लॉन्च की, तो 2 साल बाद वो डिजाइन कहीं खो जाता है, राइट? ट्रेंड्स बदलते हैं, सो वो शॉर्ट लिव्ड होते हैं, इसलिए उनको प्रोटेक्शन भी कम ही दी जाती है ताकि एक ऑर्गेनाइजेशन, कोई एक कंपनी बहुत लंबे समय के लिए डिजाइन को मोनोपोलाइज नहीं करे. उसी तरह से patent protection, we want the invention to fall in public domain so that anybody can use that invention to create more competition and to lower the prices for the purpose of accessibility. Because of all these reasons, there's limited IP protection. बाकी जो timelines है वो international law से भी flow करती हैं. You must have heard about TRIPS. It's an international agreement between different jurisdictions. WTO के अंडर वो है, जो ट्रिप्स है वो वाइपो के अंडर नहीं है. फिर वाइपो के अंडर भी बहुत सारी conventions and treaties हैं, जैसे कि Bern Convention है for copyrights, and then you have Paris for industrial property. So those international instruments also prescribe certain timelines. It could be sometimes maximum protection की इतनी दे सकते हो आप. It could be like minimum protection की आपको इतनी तो देनी ही है, right? For designs, like there could be an international instrument which says you have to give at least 10 years of protection. You can go beyond that. तो लोग कई 25-25 साल की भी कई jurisdictions देती हैं, हम 15 की देते हैं, लेकिन इतनी तो देनी ही देनी है. वो कई बार किसी इंटरनेशनल कन्वेंशन से गवर्न होता है. If you're a member of that, if India is a member of that convention or has signed that international agreement, then we are under an international obligation to give that term of protection. As far as reasoning is concerned, वो मैंने आपको बताया है कि वो एक limited term के लिए monopoly दी जाती है for certain reasons.
And ma'am, like for example, we have Apple AirPods. So if we go to any local market, we just see them like they're people are buying it within just 100 rupees and 150. So there are many people like that.
Yeah.
So why don't Apple take any action? Like it can, because there are many people, but still it does not. Why?
Why do you think that they don't take action?
Well,
They
because
do.
it's
Sometimes you don't get to know about that.
Yes.
Right. There are some markets जहाँ पे बहुत ज़्यादा counterfeits बिकते हैं. अगर आप दिल्ली में भी देखोगे तो बहुत सारे markets हैं. तो you mentioned about that. तो वो है that counterfeiting is there. The problem is rampant. बहुत ज़्यादा है हमारे country में तो ऐसा नहीं है कि वो एक्शन नहीं लेते हैं. The copyright owners or the brand owners, that they don't take action, they do. So, but they choose to take action as per their internal IP enforcement policy. So they can't go after each and every infringer, right? So sometimes वो rates भी डलवाते हैं. Sometimes तो पूरी market में जितने भी major counterfeiters होते हैं जो डिस्प्ले कर रहे होते हैं, रिटेल कर रहे होते हैं, राइट, बेच रहे होते हैं वो काउंटरफीट प्रोडक्ट्स, उनके अगेंस्ट एक साथ वो दे सू देम. कई बार कलेक्टिव एक्शंस भी होते हैं, कई बार किसी एक कोई मेजर काउंटरफीटर होता है जो बहुत ज्यादा मार्केट शेयर खा रहा है, राइट. सो उनका एनालिसिस उनको ये बताता है कि इस टेरिटरी में इतना ज्यादा काउंटरफीटिंग हो रही है, इतने ज्यादा काउंटरफीट्स बिक रहे हैं, एंड दिस पर्सन इज दिस पर्टिकुलर company is actually eating up too much of a market share, then they incur that cost of litigation, because litigation also has a cost. See, you have to, if you want to approach court and file the suit for infringement, that involves a lot of cost. You have to make a choice. तो कई बार आप 3-4 के अगेंस्ट फाइल कर देते हो सूट, 1000 के अगेंस्ट नहीं करते, लेकिन वो 3-4 के अगेंस्ट करते हो तो वो एक तरह से डेटरेंट इफेक्ट बाकियों पे भी आता है उसका. So, but that's a matter of choice. That doesn't mean you can't do it, and that doesn't mean you don't do. It's just that you don't get to know about it sometimes. They do take actions. Yeah. Anyone else? Okay, so I was talking about moral rights. Now, the rights that we were discussing about were all economic rights. You have the monopoly because you own the IP. Those are all economic rights. But then there are some moral rights as well. So if you write a script, right, and if somebody else uses that script once the IP expires, तो उसके बाद भी आपका एक moral right उसमें रहता है जो perpetuity के लिए होता है, जो हमेशा के लिए होता है. Nobody can distort that work, modify that work to such an extent that it harms your reputation. तो अगर किसी work में copyright expire भी हो गया ना, so the creator died, and after that also 60 years are over. So उसके जो legal representatives हैं can still take action against the person who uses that copyrightable subject matter, and in a manner which distorts the work to such an extent that it harms the reputation of the creator. तो इस हद तक आप उस वर्क की नेचर को चेंज नहीं कर सकते, उसका कैरेक्टर चेंज नहीं कर सकते कि उसकी रेपुटेशन को डैमेज करे वो क्रिएटर की, बिकॉज दैट क्रिएटर हैज अ मॉरल राइट. एंड मोर ओवर देयर आर टू फॉर्म्स ऑफ मॉरल राइट. वन इज राइट टू पैटर्निटी, वन इज जिसके बारे में मैंने आपको अभी बताया. देन राइट टू इंटीग्रिटी होता है, जहाँ पे आप आपका जो भी वर्क है अगर वो कहीं पे भी कोई यूज करता है, उसको कोट करता है, तो एक एट्रीब्यूट करना पड़ता है कि एट्रीब्यूशन होती है कि दिस इज दिस पर्सन राइट, आई मीन वर्क. Although you can use that without permission because the copyright has expired. अगर कोई ऑथर he has died, उसके बाद 60 साल पूरे हो गए हैं, तो then that is out of that term, right? It has fallen into public domain. You can use that without permission, but still you will have to quote. You will have to say that okay, this person wrote this. तो आपको वो फुट नोट में या कहीं पे उसको देना पड़ता है अगर आप वो पैरा यूज कर रहे हैं. So because that is flowing from the moral right of the person, and these rights are recognized under a copyright law. और ये बहुत सारे अलग कई jurisdictions में इस तरह के rights मिलते नहीं हैं, but इंडिया में हैं. हर jurisdiction में नहीं है moral rights. Economic rights बहुत सारे countries में offer किए जाते हैं, but moral rights नहीं है. So secure what sparks your imagination. Anything which you imagine, which you create, which you believe is something new. It's your expression. You must secure it, right? And imagine boldly, protect smartly. So if you imagine something, you believe that okay, if I work more on it, I can create something new. It could be an invention which can solve some problem. Then be bold about it, research more, and go and seek protection once you invent it. अगर एक बार आपकी invention पूरी हो जाती है, तो talk about it and seek guidance and go and seek protection, get the patent over it so that you can monopolize it, because you can commercialize it later on. अगर आप खुद उसमें कोई business नहीं भी खड़ा कर रहे हैं, you can license it out, right? You may not have the resources to build a business because it requires a lot of money, right? But you invented something. Then if you patent it, and if it is of certain value, then some other entrepreneur can invest in it, get it licensed from you, give you some money, license fee and use that invention and create a product and put that in the market and earn money. उसमें आपको भी value जो है वो मिलती है. Even if you don't have the resources to run the business, to start the business, but if you have an idea, you invented something, you got it patented, then it holds a lot of value and you can actually derive a lot of profits out of it. आप उसमें it's how you earn from your brilliance. So you need to recognize कि आपके ideas की, आपके inventions की हमेशा एक value होगी. तो अगर आपके पास एक बिजनेस खड़ा करने के पैसे नहीं भी हैं, तो भी जिसके पास है वो आके आपसे आपकी इन्वेंशन को लाइसेंस करवाएगा. And then he will share the royalties with you. He will give you the license fee. That's how you can earn from your intellectual property, from your inventions. And moreover, sometimes some students say that these kind of only PhD students, senior people can come up with these kind of new inventions. Students cannot. That's not true. So अगर आप copyright subject matter देखेंगे तो poem तो story तो कोई भी लिख सकता है. उसी तरह से inventions भी students करते हैं. ऐसा नहीं है कि students school students ने inventions नहीं की. Edward Thomas Clint from Kochi, he painted 25,000 paintings by the age of 7. And there's this guy, Rujhan Chaudhary from Haryana. He wrote Nannhe Pankhon Ki Udaan when he was 9. And then there's this girl named Vanilla Ethely. So she couldn't sleep without her mother. So जब वो सोती थी तो वो सो ही नहीं पाती थी जब तक उनकी mother उनके साथ में नहीं होती थी. So once she thought कि she wastes a lot of time of her mother, so she thought of inventing something. So she invented something using कुछ clothes और कुछ fur के साथ उसने कुछ नया बनाया which mimics body temperature. एंड उसने एक मोटर उसमें यूज की जिसकी वजह से वो जेंटल मूवमेंट्स भी होती थी उसमें. सो इट क्रिएटेड सम ब्रीदिंग साउंड्स एज वेल एंड इट गेव अ लिविंग ह्यूमन लाइक कंफर्ट. सो तो उसको फिर साथ में रख के वो सो जाती थी. सो शी गॉट अ पैटेंट ऑन दैट बिकॉज शी इन्वेंटेड समथिंग न्यू. तो वो कोई बहुत कॉम्प्लेक्स बहुत कुछ ऐसा नहीं था कि उसमें समथिंग वेरी ग्राउंड ब्रेकिंग, बट स्टिल it was a patentable invention because it was something new. And then this girl called Gitanjali Rao, she invented a testing device. She was also a very young girl. She invented a testing device using nanotechnology to test water contamination and impurities. And Christina Alexander, so she had different passions. उसको 3-4 तरह के अलग अलग हॉबीज थी उसकी. बेकिंग उसको अच्छी लगती थी, पेंटिंग करती थी वो, और उसको सोप्स बहुत पसंद थी, अलग अलग तरह की सोप्स बहुत पसंद थी. So she started a baking business. It failed, and then she started painting and put those paintings on sale. But वो भी ज़्यादा बिजनेस उसका नहीं चला. And ultimately she thought of making soaps of the shape of those delectable desserts that she used to bake. So डेजर्ट शेप की सोप्स बनाई उसने, अलग अलग डेजर्ट्स की शेप की. और उसकी जो एस्थेटिक जो अपीयरेंस थी सोप्स की वो डेजर्ट्स जैसी लगती थी. So that business succeeded. So she finally succeeded. She kept on trying. Right? You can have some passion, you can have some hobby if you like invest a lot of time into it, and if you believe that you can put in more effort and आप कुछ नया कर सकते हैं उसमें, must do it. बिकॉज ऐसा नहीं है कि सिर्फ रिसर्च स्टूडेंट्स सीनियर स्टूडेंट्स जो पीएचडी कर रहे हैं या स्टार्टअप्स after they are like 25 or 30 years of age, only then they can come up with something new which is valuable. Even students can, and there are many examples. So any other questions that you have, please feel free to ask. No? So I'll show you some interesting comic videos.
चलो कौन सा वीडियो कॉल which one चलो आप तो करो चला कौन सा है चलाएंगे लेकर तो बड़ा कर लेकर उसको बड़ा कर पास इंटरेस्टिंग टाइम ब्रो साउंड करो एक मिनट साउंड 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 Sit wrong. I didn't see sit at स्पीकर पे जाना नीचे वो स्ट्रीम में करो लास्ट में सही है बट फिर स्पीकर में किया करो स्पीकर ये लगा माइक आवाज इस पर इस पर लगा लेट लगा नहीं आ रहा साउंड को कैसे करेंगे आवाज तो ये किसका है आपका लड़का है ना फुल है Jesus better than दिया बैक तो क्या हो अरे इसको दिखाना गिम्बल से दिखाओ गिम्बल से दिखा दो नहीं बट वो डेट डेट लगाओ स्विच दिखा दो साउंड साउंड तो सही वाला ये भी एक्चुअली नेचुरल पे होगा अब एक छोड़ो तो स्विच कर दो बड़ा चल चलो बड़ा अब आपने गिम्बल से इसको दिखा पहले
On CIPAM's YouTube account, you can find many interesting videos of IT नानी जिसमें different forms of IT को explain किया हुआ है GI के बारे में है काउंटर के ऊपर है then access भी That you get IPs everywhere.
Which one? बताइए और नहीं कैमरे के सामने आवाज ना कोई तो हुआ मेरे को कौन सामने के साउंड है माइक मेरे को साउंड है ना और तो कभी देखा तो फिर अपनी वहां से साउंड ये रख वापस समझ नहीं
आज का बंद तो नहीं है
You can see these videos online. You can access CIPAM's YouTube account. There are many videos of IP Nani, as I mentioned earlier. Before I wind up this session, I will get a promise from you that you will never ever buy any counterfeit, and you will never let your siblings buy any counterfeit from these markets, which offer fake products for sale. अगर हमारे पास पैसे नहीं है, मान लो कि like these students, as students we have like if you have 500 but you like a bag of maybe 2500, लेकिन वो 2500 वाला जो बैग है वो फेक है, that's a fake of a 2.5 lakh bag. So you will not make the choice to buy the 2500 rupees bag. You should buy जो genuine है. It could be cheap, it may not be a branded bag, but it's genuine. एक बहुत ही हाई वैल्यू ब्रांड वाला नहीं है, लेकिन वो जेन्युइन है, वो बाय कीजिए rather than purchasing fake version of a high value brand. And you don't let others do that. Whenever your friends they want to go to these markets and buy these fake products, you will always tell them that it's a crime to sell counterfeit products, and we should not encourage those crimes, because अगर हम buy करते रहेंगे तो counterfeits grow करते जाएंगे. Okay, and this is about saying no to counterfeiting, and secondly you should also say no to music piracy. अभी क्या होता है, बहुत सारी स्ट्रीम रिपिंग वेबसाइट्स होती हैं. सम स्टूडेंट्स sometimes they want to hear songs offline, so they use YouTube downloader to download that on their device by way of ripping the stream. So that's illegal. That's online music piracy. वो लीगल नहीं होता है. तो you can get a subscription to some music app. You can tell your parents it will just cost 30 or 40 rupees per month. And then there are some music apps which run on ad revenue models. They don't ask for subscription fee. तो वहाँ पे ad revenue model पे वो चलते हैं. आपको ad देखना पड़ जाएगा 30 seconds के लिए, 10 seconds के लिए. कर सकते हैं ना, उतनी पेशेंस रखनी चाहिए. But access music from those apps which offer they have rights to offer that music. उनके पास authorization है, not from pirated websites. Similarly, movies. So there are websites online which display pirated movies. They don't have the rights to that. तो आपको कई बार पता चल जाता है. Sometimes you do the end up doing the innocent infringement. Yeah, sometimes you access certain videos or you access certain content online जो आपको पता ही नहीं है कि this is pirated. That's okay. But you should do your due diligence to know कि अच्छा ये pirated content है, pirated website है, या ये actually genuine website है. Because you are all educated students, well aware, you can figure out that this is a pirated website. Songs.pk से हमारे टाइम में हम बहुत songs सुना करते थे, but then we got to know about this IP thing, and we were made aware that this is illegal. जो इस तरह की websites चलाते हैं. Then we stopped consuming music from those pirated websites. And counterfeiting की बात हो गई, music piracy की बात हो गई, film piracy की बात हो गई, and now about inventions. So never think that you can't invent anything new. You are not well equipped to, you're not intelligent enough to come up with something new. You can always come up with something new, something useful, something having industrial application which can solve a problem. You all are well equipped and intelligent enough to do that. And once you do that, share it with your teachers, tell them, ask them, how can you protect that IP? There would be someone who can facilitate with the patent filing. Patent filing हो सकती है, आपका IP protect हो सकता है. And also design infringement. Design infringement, maybe just say no to, buying those kind of bags या उस तरह का stuff, उस तरह के products जहाँ पे किसी का design किसी ने चोरी किया हुआ है. आपको उसकी cheaper version मिल रही है, आपको लगता है कि ये सेम ही शेप है, मुझे जो 1000 रुपए का प्रोडक्ट है मुझे 100 रुपए में मिल रहा है, आई शुड better buy this. No, buy a cheaper genuine product than a fake version of a high value brand. Always go for genuine, never opt for fake products. Promise me you'll do that. Thank you. Thanks.
Thank you, ma'am. Your invigorating thoughts have enlightened our mind, shown us a new path.
I now invite our Vice Principal, Miss Indrajit Kaur, to render the vote of thanks.
Good afternoon, everyone. It's my honor to propose the vote of thanks on behalf of Delhi Public School Mathura Road. We extend our heartfelt gratitude to Ms. Simrat Kaur, Director Intellectual Property Rights, DPIIT, Ministry of Commerce and Industry, Government of India, for her insightful and inspiring address. Ma'am, your clarity of thought, practical perspectives, and emphasis on ethics and creativity have greatly enriched our students' understanding of the importance of intellectual property rights in today's world. We are sincerely thankful for your valuable time and guidance. Our sincere thanks to the Ministry of Commerce and Industry and DPIIT for facilitating this meaningful IPR awareness programs for all the students, those present here on campus, and those who joined us online. We hope today's session inspires everyone to value originality and safeguard their creative ideas. I extend my thanks to all school leaders, teachers, and students from various Delhi public schools who have joined this program live from different parts of the country, making today's session truly meaningful and engaging. I would also like to acknowledge the steadfast support and vision of our principal, Dr. Ram Singh, in absentia, whose guidance makes such initiatives possible and impactful. Once again, we extend our deep gratitude to you, Ms. Simrat Kaur, for gracing us with your presence. Thank you.
Thank you, ma'am. I now request everyone to kindly rise for the national anthem. जनगणमन अधिनायक जय हे भारत पंजाब सिंध हिमाचल जन जन शुभ जागे तुम शुभ आशीष मांगे गाते तव जय गाथा जय जगन के भारत भाग्य विधाता जय हो जय हो जय Thank you. God bless you.